Hi guys, it's Kathy. I hope you're doing well. It looks like Twitch chat is not going to cooperate today, but it might because I got it fixed during OJ, I think. So we might have Twitch chat today. I think we do. It's just there's only one text in there so far. I think that's the problem. Jude, thank you so much. Thank you so much for the gifted memberships. That's so nice. All right. Today we go to two different courtrooms. We're gonna check in on Christofino because we haven't seen him in a while. I showed him in a video a little bit ago, but we haven't actually been to Elkhart courtroom in a while, so we're gonna do that. And my dog's gonna join us. And then I'm so sick of animals. I don't want to live with no animals for a month, just a month. And then we're gonna go to El Paso, Colorado, not El Paso, Texas, because El Paso, Texas is annoying. Hold on, I'm going to see if I can show you. While my dog speaks to you. Where's my Texas? Oh, that's not it. Tacoma, Sacramento, Missouri. There it is. It's gone. Okay, that makes sense. I was trying to get El Paso, Texas for a while, but the stream is not. I'll keep working on it. All right. I don't know, Kelly. It's not up yet, but thank you for the bits. Hopefully, when I switch over right now, we'll see that. Hopefully. Hopefully. Let's try. Nope, it's not showing up. Son of a.
Claims of perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
State your name for the record.
Kevin Starr.
Thank you. Show the defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Chief Deputy Public Defender Bridget Faulkner. State of Indiana in court by Deputy Prosecuting Attorney Robert Swaby. Mr. Starr, you appear for sentencing, having pled guilty to auto theft, a level 6 felony in F6 539, and resisting law enforcement, a Class A misdemeanor in CM 1086. Is that your understanding?
Yes, Your Honor.
Of the proceedings?
Yes.
Now, I want to be clear on this. When you gave your factual basis to the court under oath, did you give a true and accurate factual basis for these two crimes?
Yes, Your Honor.
And you want to go forward with sentencing today and get the benefit of the plea bargain agreement, correct?
Yes, Your Honor.
So credit time on each of these is day for day or 50%. Do you understand that?
Yes.
Any questions about credit time?
No.
You understand you waived your right to appeal your conviction and sentence in this case?
Yes.
Did you review the pre-sentence investigation report?
Yes.
Did you review it with Ms. Faulkner?
Yes.
Any amendments, Ms. Faulkner?
Not necessarily to the pre-sentence investigation report, Your Honor, but I did realize that I inadvertently had Mr. Starr sign the incorrect plea bargain agreement. And instead of 2 years in the F6 case as terms, it should have said 18 months.
Is that correct, Mr. Swaby?
Yes, there's no objection to that amendment.
I apologize for that, Mr. Starr.
I appreciate that.
if this is your first time with Judge Cristofino, get ready because he is a stickler for laws and rules. He is a stickler.
Any other amendments?
He's special. I love him.
Mr. Swaby, any amendments?
No amendments.
Pre-sentence investigation report is approved as amended. Arguments. Go ahead, Ms. Faulkner.
Thank you, Your Honor. I would simply ask the court to sentence Mr. Starr accordingly. Elkhart County Community Corrections has filed eligibility reports saying that they would agree to supervise him. Mr. Starr would ask that he be released and allowed to
Of course he was released. Kelly, thank you for the bits. Thank you.
report on a given date so that he can spend at least a little bit of time with his daughter before he goes. Thank you.
Your Honor, before you accept or deny
Thank you.
that.
Whoa,
It's not your turn yet,
whoa.
okay?
Sorry,
Well,
sorry.
not your turn to talk yet. Thank you, Ms. Faulkner. Mr. Swaby, anything?
No.
Now your turn to talk. What do you want to tell me, Mr. Starr?
Before you accept or deny this, I have been at 3 previous instances to MCC, all which given a commitment date. I have completed every commitment date given to me. I've never had a failure to appear to court. That's why I want to argue with me, hopefully getting this accepted. Tomorrow, my daughter, I want to see her. I promised her I'd be there. I wasn't there last year, so it's kind of like a big ordeal to me and her, and I would be very grateful if you allow that.
I've already accepted this. Do you understand that?
Yes, that's my commitment date. Give me a commitment date to appear. I want an immediate release and with a commitment date.
Okay.
Monica, look at you go. Monica's 2 months on Twitch as a subscriber. The reason why Twitch is good as a subscriber,
Cost committee on
hold
for
on,
sentencing defendant
Christopino.
appears in
Hold on.
person.
if you have Prime, Amazon Prime. Okay, I should back up. If you're watching YouTube and you're seeing ads, you know, that's not fun. But if you have Amazon Prime, you get a free subscription to a Twitch channel every month. And if you subscribe to the Twitch channel and watch this live stream on Twitch instead of YouTube, there's no ads if you have a subscription. So you don't have to, it's free for you and you don't have to watch ads. So Twitch is up if you want to watch without any ads. But Linus is on Twitch right now, but she has a YouTube membership. So she doesn't see ads on YouTube. Oh no, she does. I don't know if she does. But she definitely sees ads on Twitch. So Linus went over to the ads. She must like the ads over there. I wonder what kind of ads they are. Monica, thank you for the cheers. Appreciate it.
In the Elkhart County Correctional Facility via WebEx and by Chief Deputy Public Defender Bridget Faulkner in person. State of Indiana in court by Deputy Prosecuting Attorney Robert Swaby. The pre-sentence investigation report is approved as amended. Court hears arguments from counsel. Court hears a statement from the defendant. In F-6539, defendant sentenced pursuant to the plea bargain agreement on auto theft, a level 6 felony, to 18 months at the Indiana Department of Correction. That executed sentence to be served alternatively.
Whoa, wait. Okay, couple things just ran. What just happened? Okay. Auto theft. A level 6 felony? It's the lowest possible felony it could possibly be. A level 6? That doesn't make any sense. Auto theft, when I was growing up, Grand Theft Auto was a big freaking deal, and you went to jail for a long time if you stole a car. So it shouldn't be a level 6 felony. Shouldn't it be higher? Shouldn't it be just a little bit more? But then he gave him 18 months for a level 6 felony. So giving him 18 months for auto theft, okay, that's fine. I wish it was more, but it's fine. But giving him 18 months for a level 6 felony, that doesn't make sense. I don't even know what just happened there.
$18 months at Elkhart County Community Corrections at a level to be determined by Elkhart County Community Corrections, but the court recommends work release. Elkhart County Community Corrections to transport the defendant from the Elkhart County Correctional Facility to Elkhart County Community Corrections. In CM 1086,
It's Indiana.
pursuant to the plea
Yep.
bargain agreement, defendant sentenced on resisting law enforcement, a Class A misdemeanor, to 1 year at the Elkhart County Correctional Facility. Again, this 1 year executed sentence shall be served at Elkhart County Community Corrections at a level to be at the discretion of Elkhart County Community Corrections, but the court recommends work release. Elkhart County Community Corrections to transport the defendant from the Elkhart County Correctional Facility to Elkhart County Community Corrections. Defendant ordered to pay court costs. Defendant ordered to pay a fine of $1,000 in F6539 and $500 in CM 1086. Those fines are suspended. Defendant ordered to pay in F6539 $200 public defender fee to the clerk of the court. Is there any restitution? I didn't see
I
anything.
don't believe so.
I don't.
There wasn't any filed. It was filed with the PSI, and we never received a response to the sentencing letter that we sent out or our initial contact.
Defendant is found not to be indigent because defendant will be employed while on Elkhart County Community Corrections. Defendant admonished that the law does not allow and this court will not incarcerate the defendant for failure to pay fines and costs if the defendant is indigent. Defendant ordered to provide a DNA sample at his cost pursuant to statute if he's not already done so. Defendant ordered to have an addictions evaluation and a mental health evaluation and follow up with any recommended treatment. Defendant given credit for having served 104 actual days in custody plus good time credit for statute. Pursuant to the plea bargain agreement, the sentences in the causes are to run concurrently. Bond is released. Appointment of the public defender's office is withdrawn. The order of commitment is entered. The defendant is remanded in custody of the sheriff of Elkhart County, who's ordered to carry out the provisions of this sentencing order. It is so ordered.
Thank you, Judge.
Thank you, Ms. Faulkner. Thank you, Mr. Starr. You're all done.
Does that mean I won't have a commitment date?
Pardon?
Oh, that means I'm not granted a commitment date?
No. What's going to happen is Elkhart County Community Corrections is going to come and pick you up and take you over to their facility.
Okay, Your Honor. Thank you.
Good luck. Mr. Cassell, are you there? Castle, excuse me. Castle, are you there?
Just so you know, I don't get to pick how much subscriptions cost on Twitch. Twitch picks it, and I can't change it. Assholes. I got a mute button now, and it's working great, guys. See, I'm not. It's great. My whole life changed.
20C01-1911 F6 1564 State of Indiana versus Travis E. Castle. Mr. Castle, raise your right hand. You swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth.
Yes, sir.
State your name.
Travis Edward Castle.
Should defendant appears in person from the Elkhart County Correctional Facility via WebEx by his attorney Matthew Johnson, State of Indiana in court by Deputy Prosecuting Attorney Robert Swaby. Mr. Johnson, go ahead.
Thank you, Your Honor. It was my understanding, and I believe Mr. Castle's understanding, that when we entered the admission on his other two cases, that we were doing it on this one as well. So I guess we can go forward with the further admission. However, the court's already violated him on it. He's already made a factual on it and everything under the other cause numbers. That's 20C01-19 F6 255 and 20C01.
For whatever reason, we didn't handle this case when we handled the other two?
Yeah, so let's handle it today with with a admission. Since he's already, and as far as we're concerned, he's already essentially admitted to this violation.
Hold on a minute. Okay, for the record, Mr. Castle, did you hear the rights that I read to you previously? Are you waiving those rights, and are you admitting that you violated?
Yes.
Hang on a minute. Hang on a minute.
No, I meant it.
Violated
They're
his placement
assholes.
on probation.
So, $5 a month or $6, I don't know what it is. That's stupid. It's just stupid. They should let me pick.
Yes.
And you're doing that without a trial, correct?
Yes.
Factual, go ahead.
Thank you, Mr. Castle. You were on probation in this matter, correct?
Yes.
And
I can pull it. One second.
I'm sorry, Your Honor. I need to. Mr. Castle, you tested positive for methamphetamine, correct?
Yes.
On February 4th and February 13th.
Yes, sir.
And you tested positive for methamphetamine because in fact you used methamphetamine.
Yes.
You had no legal reason to be using methamphetamine, correct?
Definitely not.
Nothing further.
Mr. Swaby,
No questions.
court finds the defendant waived his rights, his right to trial, and
Kelly,
admitted
thank
violating
you.
probation
Thank you for the
specifically
cheers,
by
Kelly.
using methamphetamine. I think this got transferred in after the others were done, is where I think the problem is. I mean, this is what's wrong with these transfer of cases. On some instances, we're not getting them until the case is already resolved. Or the other case we had was already resolved. Do you have credit time on this?
I don't have.
It wasn't on the other credit time memorandum.
Yeah.
That's another reason why we didn't do anything with this. I mean, here we go. Mr. Castle, did you just have 1 year on this one?
Yeah. No, it was 2 3-year terms. You put one on ECC last time, and then this one was, I thought they were putting it, and it was gonna turn like my terms into 4.5 years on work releases when I thought we did, but I mistaked.
I think he's only got 1 year on this case, though.
I'd agree with that. That's what I saw.
Arguments, go ahead.
Thank you, Your Honor. The court has given Mr. Castle work release on his other two cases, so he's going to spend a significant time there. I think that it could be appropriate to allow this case to come after the other ones to create some sort of a step down program for Mr. Castle. So once he's done a good chunk on work release for him to either be on home detention or onto probation on this case. Thank you.
Thank you, Mr. Swaby.
Thank you, Your Honor. State would ask the court to have the sentence imposed at community corrections to match the other cases. If it gets to the point where probation might be appropriate, I would suggest it would be appropriate just for him to be able to make that request through a modification of the court. Thank you.
Thank you. Mr. Castle, what do you want to tell me?
Just that I thought that we already did this and that I apologize. I know I messed up. I know I did, but I'm ready to get back to work and I'm going to show you guys that I'm not going to come back in front of you again. And that, I hope that the 3 years that I did out after Westville was enough to determine that. That I didn't just, I wasn't out there committing new felonies. I wasn't out there I was using, but I was working every day and I was paying my stuff and everything. So, I mean, I just want another chance is all.
Okay, and I'm going to tell you what, I think what would be better all the way around is rather than me put the step down approach in place here, let's see how you do at Elkhart County Community Corrections and see where you're at. And then if you get in a position where you're off of work release, you're on home detention and things are going well, you're on there for a while, I think that would be the time that we ought to look at modifying your sentence. Okay.
Okay.
And give you, I agree with what both Mr. Johnson, Mr. Swaby said. I just am implementing it more like what Mr. Swaby proposed. And I think that's because it's going to be a benefit for you. I just think you need some structure. You were at the DOC, you just got to get used to being back in society where you got all these decisions you got to make every single day, and people don't realize it, but it's hard at the DOC. In some respects, much harder than being out here free. In some respects, it's easier. They make all the decisions for you. You don't have to decide anything. They decide what clothes you're going to wear, what foods you're going to eat. I mean, you just don't have any decisions. So let's see if we can get you in a position where you get through this and get it behind you.
Okay.
Cost being on for hearing
need
on
that.
alleged violation of probation, defendant
need
appears
that.
in person, in the Elkhart County Correctional Facility via WebEx and by his attorney, Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorney Robert Swaby. Defendant
Bobby.
waives his rights and his right to trial and admits.
Bobby, are you near Elkhart, Indiana? Are you near that? Because you can break the law this weekend and get in front of Judge Cristofino and we can watch you on YouTube. You could do that for us. Just break the law. Just steal a car. It's a level freaking 6 felony. Who cares? It's the lowest possible felony. And you get a car. I would spend 18 months in jail for a free car. Although you don't get to keep the car. But you could keep the car if they can't find it. I think I'm doing something illegal by talking you into committing a felony. So, I'm joking. Ha ha.
It's violating probation specifically by using methamphetamine while on probation. Court hears arguments from counsel. Court hears a statement from the defendant. Court now sanctions the defendant to serve the remainder of his 1-year sentence at the Indiana Department of Correction with alternative placement at Elkhart County Community Corrections at a level to be determined by Elkhart County Community Corrections, but the court recommends work release. The sentence in this case shall be served consecutive to 20 CL1 1907 F6 1015 and 20 CL1 1911 F5 255. Elkhart County Community Corrections ordered to transport the defendant from Elkhart County Correctional Facility to Elkhart County Community Corrections. Court orders probation to prepare and file with the court a written credit time memorandum. Court will award credit time upon receipt of that memorandum. It is so ordered. Good luck to you, Mr. Castle.
Thank you.
We should have a marathon. We should have a a competition, guys. We should have a competition to see who can Who can get on the most dockets this month? How many dockets can you get yourself on this month?
20 CL 1903 F6 443, State of Indiana versus Christian S. DeLucine. Please raise your right hand. You swear affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes.
State your name for the record.
Christian Seth Delucine.
Thank you. So the defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorney Robert Swaby. This matter comes on for hearing on alleged violation.
No, neither. Neither. Can you?
Yes.
And go ahead.
No, can you do it in Bleckley County or Washington County or Toombs County or Lawrence County? Or Lawrence? Did I say Lawrence? Dawson. You can break the law in Dawson. We'll see your initial appearance. It would be awesome if it was Toombs and then Judge Reeves would stream it. But DeKalb and Fulton are YouTube judges. I'll still play you. I would play a YouTube judge for you.
Mr. Johnson.
Thank you, Your Honor. We're asking for ECC and MCC evaluations and to come back as soon as those are available.
Do we have a credit time memo?
I don't think that we do.
I'm going to get
You
that
are
too.
correct.
Hang on a minute. Let me just make sure. I don't think we do.
Bleckley. That way you get Judge Crawford. Crawford? No, that's not right. What's his name? What's the cranky judge's name? Where's Miko?
Cause coming on for hearing on alleged violation of probation. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorney Robert Swaby. Court orders Elkhart County Community Corrections and Michiana Community Corrections to file eligibility reports with the court. Court orders Elkhart County Probation to prepare and file with the court a written credit time memorandum. Court resets this matter for further hearing October 1, 2025 at 8:30 a.m. It is so ordered. I'm going to see you back here October 1, okay?
Yes, Your Honor. Thank you.
Thank you.
He's
Is that
in
you, Mr.
red.
Horvath?
Yeah.
Why is he in red?
Give me just a minute.
No, the cranky judge. Judge Crawford, I think. Crawford, Coughlin. Just can't nail his name down. The cranky judge. From Georgia. You know, Mr. Kelly. Mr. Kelly, if I have to tell you one more time, don't you point at me. I think so, because everybody else is wearing orange. He's wearing red, so it has to mean he got in trouble. Or it could mean he's like team leader. What do they call them? Not responsible. They're... I can't think
I'm
of
sorry,
words.
Mr. Horvath. 20 CO 12501 F632, State of Indiana versus Dante M. Horvath. Please raise your right hand. You swear affirm under the pains of perjury that the testimony you're about to give will be the truth? 66%.
Yes.
State your name for the record.
Dante Horvath.
Thank you. Put your hand down. Show the defendant appears in person from the Elkhart County Correctional Facility.
I don't
via WebEx
think
and by his attorney
so.
Matthew Johnson, State of Indiana, in court by
I don't think they dress you for your crime. They dress you for how you act in the prison. So, like, what are the ones who they get to go where they want? Oh, there's a word. I'm wearing red because I'm a trusted. Is it trusted? but I don't, trustee, maybe that's what it, JK, trustee. So he's either been bad and is in red because he was misbehaving and now he's in a special red unit, or he's a trustee, which means he's been really, really good. But we don't know. I don't know because I don't know Indiana garb.
Deputy Prosecuting Attorney Robert Swaby. Mr. Johnson, go ahead.
Thank you. Mr. Horvath would like to admit his violation.
Is that correct, Mr. Horvath?
Yes.
So are you telling me that you heard your rights, you're waiving those rights, and that you're going to admit that you violated your placement on probation without a trial?
Yeah.
Was that a yes?
Yes.
Thank you. Factual basis.
Thank you. Mr. Horvath, you were on probation in this matter, correct?
Yes.
However, if one of the terms of probation was that you needed to report to Elkhart County Probation after you were released from jail, correct?
Yes.
And you failed to do that, correct?
Yes.
Nothing further.
Mr. Swaby?
No questions.
Well, I just looked it up, guys. Definitely not a trustee. Absolutely not a trustee. It's actually more a Kit Kat. You could have been dead on right. I don't think it's a crime. I don't think they dress you for your crime. But crimes like murder make you a more so in general, a red uniform signifies high risk or violent inmate. He's probably beating up the other inmates. So Elkhart County, they don't tell you exactly what their colors mean. They don't post that. But generally it's deemed a maximum security or high risk prisoner. Oh, solitary confinement. So probably he might have did something very bad for his crime.
Court finds the defendant waived his right to trial, admitted that he violated probation by failing to report to probation as ordered by the court. Arguments. Go ahead.
Thank you, Your Honor. This was a 1-year suspended sentence, of which Mr. Horvath has now served 113 actual days. There is a credit time memo in Mr. Horvath did not do what he was supposed to do when he got out of jail. He's now served quite a bit of time for that, an additional 55 days on top of the time that he did before. He is as he's there in the jail. You can see that he's wearing red. He is an inmate worker. So while he's in, he's making it some progress. What we're asking
And then the defense attorney just told us we're all wrong and the internet is wrong. He's wearing red, means he's a worker, means that he's doing well, means it's a good thing.
is for a time served sanction and to discharge him from probation. He would only have a little bit over 60 days worth of time left, and I think that's appropriate under this circumstance for somebody who had a 1-year suspended sentence to end up doing 113 days. I think that we should call it good enough and unsuccessfully discharge him. Thank you.
Mr. Swaby?
Thank you, Your Honor. State would ask the court to not discharge him at this time, particularly given that we have a violation here. The court wants to consider discharging him early and have him serve time. The state would suggest having him serve at least 75% of his sentence, if not the full amount. 75% would be 135 days, about 22 more days. Otherwise, the state would suggest the court to adopt probation's recommendation. Thank you.
Mr. Horvath, what do you want to tell me?
Nothing.
Pardon?
I don't have anything to say.
Oh, okay. Give me a moment. Cause coming on for hearing on alleged violation of probation. Defendant appears in person to the Elkhart County
Very
Correctional
smooth.
Facility via WebEx and by his attorney, Matthew Johnson, State of Indiana in court by Deputy Prosecuting Attorney Robert Swaby. Defendant waives his rights and his right to trial and admits violating his placement on probation by failing to report to probation. Court hears arguments from counsel. Defendant declines to give a statement. As a sanction, court revokes the defendant's placement on probation, reimposes the remainder of the 1-year sentence to the Indiana Department of Correction. Court vacates all but 140 days of the executed sentence. Defendant given credit for having served 113 actual days in custody plus good time credit per statute. Go back, I said that incorrectly. Not 140, but all but 280 days. All but 280 days. Court vacates all but 280 days of the original sentence. Defendant given credit for having served 113 days plus good time credit per statute. Defendant unsatisfactorily discharged from probation. Bond, if any, is released. The appointment of the public defender's office is withdrawn. The order of commitment is entered. Defendant is remanded to the sheriff to carry out the executed sentence. And you're going to be released as soon as you get as soon as you get in, I think it's 27 more days. Good luck to you, Mr. Horvath. No, I didn't see.
Oh.
Hey, jail,
Yes, Your Honor.
I'm gonna do Ms. Madison here, but anybody who needs an interpreter, I see that Mr. Aguilar has, I think, has logged on. So I know that Luis Velos de Jesus, let's see if we can get anybody who needs an interpreter and get those cases done, please.
Yes, Your Honor.
Twenty CO1 2312 F6 1496, State of Indiana versus Kayla M. Madison. Please raise your right hand. You swear or affirm under the pains of perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
State your name.
Kayla Madison.
Show the defendant appears in person from the Elkhart County Correctional Facility via WebEx and by her attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorney Robert Swaby. Violation hearing, go ahead.
Thank you, Your Honor. I think that we need to go for a bond report today. Or we need to do bond today.
Okay. Did you have a chance to review the bond report with your client?
I did.
Any amendments?
We didn't have any amendments, Your Honor.
Mr. Swaby, any amendments?
No minutes.
Bond report approved as filed. Argument. Go ahead, Mr.
Thank you, Your Honor. We're asking the court for a bond in this case. She's currently on a no bond hold. We're asking for that bond to be $3,000 or less surety. So I would note that from her criminal history, her juvenile history is more substantial than her adult. That being said, I don't believe that she has any failures to appear. She went all the way through her case that we had. She never failed to appear. I don't think that there's any reason to think that she would. This was a theft case to start with. She does currently still have her apartment. She's trying to be able to keep for herself and her children. Her children are currently being taken care of by her mother, who's struggling with that. Right now, she's trying to bond out so that she doesn't lose everything. That being her apartment, that she's getting some assistance with. And to get out and to get to work. So
why does her probation officer recommend that she be held without bond?
it's a good question.
Yeah, I thought it was a pretty good question.
Yeah, on a level 6.
Because I'm reading from the report and it says that the person who prepared the report spoke with Ms. Madison. I'm direct reading now.
Yeah.
With Ms. Madison's probation officer, who recommended Ms. Madison be held without bond pending disposition of the violation. I
would also note that Miss Madison was re-engaged through Oak Lawn. That's in the report in dual treatment as recently as June. The violations are based on earlier failed marijuana screens.
Thank you. Mr. Swaby, go ahead.
No argument on bond from the state court's discretion.
Ms. Madison, you got anything you want to tell me? Be careful.
Yes, I'm just hoping I can get a chance to bond out so I don't lose everything that I've worked hard to get. And I need to get to my kids so I can take care of them because it is hard on my mom, like Matthew said. And that's all I have to say. Thank you. And I also did turn myself in as well.
Yeah, you did. I noted that. Thank you for reminding me, but I mean, I did note that, Ms. Madison,
Okay.
which is why I was also wondering why. I have a lot of questions, but I don't think you can answer them. Are you getting along with your probation officer okay?
Yeah, it was pretty much for the most part.
Tina P, 2 months. Thank you so much. Thank you. Thank you, Tina. Oh, he's thinking for a long time, guys. That's never good for her. That's never good. Those were the days. Then I wrote one sentence in my Discord in those days, and I got other
What else
channels
do you want
mad at
today,
me.
Mr. Johnson?
I got two other channels mad at me.
Other than the bond, ECC and MCC evaluations. We just worry without the bond that those may.
What are you
have
saying?
other- What was that?
What are you saying?
I think that with it, without the bond though, those could have some additional issues.
You're totally losing me. Without, what do you mean, without the bond, you could have
I
additional?
think that if she loses her home, she's probably not going to be eligible.
Oh, I see what you're saying.
Yeah.
Mm.
Josh, how are you? Out of 10, 10 being the best, 1 being the worst, are you at least a 5 right now?
Cost coming on for hearing on alleged violation. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by her attorney, Matthew Johnson, state of Indiana, in court by Deputy Prosecuting Attorney Robert Swaby. The bond report is approved as filed. Court hears arguments from counsel. Court hears a statement from the defendant. Court grants the defendant's motion for bond and sets bond in the amount of $6,000 corporate surety. Court orders Elkhart County Community Corrections and Michigan Community Corrections to file eligibility reports. Court orders probation to prepare a credit time memorandum. Court resets this matter for further hearing October 1, 2025 at 8:30 a.m. Ms. Madison, here's the deal. I know Mr. Johnson asked for $3,000. I do not feel comfortable doing that because I do think this is a probation violation and your bond ought to be elevated because you've already been convicted of a crime and now you violated and your record is not the greatest, even though it's mostly juvenile. I did not go up as high as some others because I do think you ought to have a bond on this. And that's the reason why I gave it. It's more than what the standard
Thank you,
bond would
Monica.
be
Thank you,
for-
Monica.
if this were at the initial hearing stage of new crimes, and it's not. That would have been 4,500, I believe, and we're not at that stage. So it's a little bit higher, but it's not a lot higher. If you can make that, you're going to bond out, and you got a shot. If you can't make that, then I don't know what's going to happen. But you're going to see me back here October 1.
Hi,
Okay.
Lizzie.
Okay, thank you, Your Honor. Have a good
Bet.
day.
Good luck to you, Nick Reese. Wait a minute. Hang on a minute.
No.
Was that our translator case?
No,
Yes, Your Honor.
Have him step back in.
2023 is when I started. I mean, I've been on YouTube longer than that, but 2023 is when I started posting videos.
Let's see if I can get Mr. Aguilar. Mr. Aguilar, are you there?
Yes, I am, Judge. Good morning.
I'm sorry, I didn't see you on here. I'm not really with it this morning for some reason.
Not a problem, Judge.
How many people do you have on your list? Is it just Vilos de Jesus?
That is the only one that I am aware of, Judge.
Let's see if that be it. Hang on a minute. Mr. Yoder, are you there?
Yes, I am.
Great.
I need more coffee. Just listen to Christofino for a while, guys.
20 CL1 2508 F6 894 State of Indiana versus Luis Velas de Jesus. Mr. Aguilar, please raise your right hand.
Yes, Judge.
You solemnly swear or affirm under the penalties of perjury that you will justly, truly, and impartially interpret to Jesus Velas de Jesus the oath about to be administered to him, and the questions which may be asked him, and the answers that he shall give to such questions relative to the case now under consideration before this court.
I do.
You take that same oath as to any other individuals who require a certified interpreter today.
Yes.
State your name for the record.
Adrian Aguilar?
Are you a certified interpreter?
Yes.
Is your native language Spanish, and did you learn English?
Yes.
Have you served as a certified interpreter for this court and other courts in Elkhart County way over 1,000 times?
Yes.
Will you notify the court if you have any problem in translating the proceedings?
Yes.
Do you agree to be bound by and will you follow the Indiana Supreme Court Interpreter Code of Conduct and Procedure in effect at this time?
Yes.
I now order you to interpret the proceedings word for word. Will you do so?
Yes.
Mr. Velez de Jesus, raise your right hand, please.
Señor Veloz de Jesús, levante su mano derecha, por favor.
Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Que si usted jura o afirma bajo las penas y penalidades de perjurio que el testimonio que usted está a punto de dar será nada más que la verdad.
Yes.
Yes.
Please state your name.
Por favor, declare su nombre.
Luis Gerardo Veloz de Jesús.
Luis Gerardo Veloz de Jesús.
What's your date of birth?
¿Cuál es su fecha de nacimiento?
0823-1976.
0823 of 1976.
You may put down your hand.
Usted puede bajar su mano.
Show the defendant appears in person from the Elkhart County Correctional Facility
Enseño que el acusado comparece en persona desde la cárcel del condado de Elkhart
via WebEx
por Webex
and by his attorney,
y por su abogado,
Mike Yoder,
Mike Yoder.
both by WebEx.
Los dos a través de Webex.
State of Indiana in court by Deputy Prosecuting Attorney Robert Swaby.
El estado de Indiana en el tribunal por el fiscal adjunto Robert Swaby.
Certified interpreter Adrian Aguilar appears via WebEx and translates the proceedings for the benefit of the court and the defendant.
Intérprete certificado Adriana Aguilar comparece a través de Webex y traduce los procedimientos para el beneficio del acusado y del juez.
Mr. Velas de Jesus, you are here for an initial hearing
Señor Veloz de Jesús, usted está aquí para una audiencia inicial
because the state of Indiana charged you with identity deception,
porque el estado de Indiana lo ha acusado a usted con decepción de identidad,
a level 6 felony.
un delito mayor nivel 6.
That charging information reads as follows.
Esta información de las acusaciones lee de la siguiente manera.
On or about June 9, 2025,
En o alrededor el día 9 de junio del 2025,
at the County of Elkhart, State of Indiana,
en el condado de Elkhart y en el estado de Indiana,
when Luis Velas de Jesus,
uno Luis Veloz de Jesús,
with intent to defraud or harm
con la intención de defraudar o dañar
Hector Roldan Luna,
a Héctor Roldán Luna,
another person,
otra persona,
did knowingly obtain, possess, transfer,
a sabiendas obtuvo, poseyó o transfirió
or use identifying information
o usó la información de identificación
to profess to be another person,
para pretender ser otra persona,
all of which is contrary to the form of
todo lo cual es contrario a la forma de
Indiana Code Section
la sección del Código de Indiana
35,
35,
43,
43,
5,
5,
3.5a.
3.5a.
I will enter a preliminary plea of not guilty for you at this time.
Yo ingresaré una declaración preliminar de no culpable de su parte en este momento.
You have the right to a public and speedy trial by jury.
Usted tiene el derecho a un juicio sin temor abierto al público y el derecho de tener un juicio ante un jurado.
You cannot be compelled to make any statement or testify against yourself at any hearing or trial.
Usted no puede ser obligado a testificar en contra de sí mismo y de dar alguna declaración en ninguna audiencia o juicio.
But you have the legal right to remain silent.
Pero usted tiene el derecho legal de permanecer bajo silencio.
Anything you do say can be used against you.
Cualquier cosa que usted diga sí pudiera ser usada en su contra.
You have the right to face all witnesses against you
Usted tiene el derecho de enfrentar a todos los testigos en contra de usted
and to see, hear,
y de ver, escuchar
question, and cross-examine them.
y de ver, escuchar, cuestionar y contrainterrogarlos a ellos.
You have the right to retain an attorney to represent you,
Usted tiene el derecho de retener a un abogado para que lo represente a usted.
and if you intend to retain your own attorney,
Y si usted tiene las intenciones de retener a su propio abogado,
you must do so within 20 days from today,
usted debe de hacerlo dentro de 20 días de la fecha del día de hoy,
since there are deadlines for filing certain motions and raising
que-
certain defenses.
dado que hay fechas límites para levantar ciertas mociones y levantar ciertas defensas.
And if those deadlines are missed,
Y si esas fechas límites se pierden,
the legal issues and defenses
los problemas legales y defensas
that could have been raised will be waived.
que se pudieran haber levantado serían renunciadas.
If you are unable to afford an attorney,
Si usted no tiene los medios económicos para un abogado,
you have the right to have an attorney appointed to represent you at no expense to you.
usted tiene el derecho de tener un abogado que sea nombrado para que lo represente a usted a ningún gasto a usted.
Private counsel, Mr. Yoder, has appeared on your behalf.
El abogado privado, el señor Yoder, ha comparecido de su parte.
Your jury trial is scheduled for December 8, 2025 at 8:30 a.m.
Su juicio ante un jurado está programado o establecido para el día 8 de diciembre del 2025 a las 8:30 de la mañana.
Do you acknowledge on the record that your case is scheduled for jury trial
Que si usted reconoce para el acta que su caso está programado para un juicio ante un jurado
December 8, 2025 at 8:30 a.m.
el día 8 de diciembre de 2025 a las 8:30 de la mañana.
Mr. Velas de
Hi,
Jesus, do you
Sherry.
acknowledge that your case is scheduled for jury trial December 8, 2025 at 8:30 a.m.?
Señor Veloz de Jesús, que si usted reconoce que su juicio ante un jurado está programado para el día 8 de diciembre de 2025 a las 8:30 de la mañana. Yes.
Do you understand that if you don't show up for that jury trial, the court will hold the jury trial without you?
¿Entiende usted que si usted no comparece para su juicio ante un jurado, el juez realizará su juicio ante un jurado sin usted? ¿Más fuerte, señor?
Sí.
Yes.
Mr. Yoder, would you like the court to consider a bond reduction?
Señor Yoder, ¿le gustaría que el juez considere una reducción de la fianza?
Not at this time, Your Honor. I'm actually suggesting or requesting that this cause be transferred to Elkhart Superior Court number 4.
No en ese momento, su señoría. En ese momento yo estoy solicitando o recomendando que o pidiendo que esa causa sea postergada al Tribunal Superior de Elkhart número 4.
Only because he has a pending probation violation that I represent him on in Superior Court number 4 also.
Solamente porque él tiene una pendiente violación de libertad condicional en el Tribunal Superior número 4, en la cual también lo estoy representando a él.
Well, much to my chagrin,
Bueno, aunque no quiera,
the water does not flow in that direction.
el agua no fluye en esa dirección.
By that I mean,
Y con eso
Judge, we have a lot of Australians here, and their water flows in that direction. So be nice. Be inclusive.
me refiero que
it is much more likely that Judge Bellin
es mucho más probable que la jueza Bellin
will transfer her probation violation to this court.
transferirá su violación de libertad condicional a este tribunal.
I would suppose that if you can convince Judge Bellin
Yo supongo que si usted puede convencer a la jueza Bellin
to take this case on transfer,
de que tome este caso en transferencia,
I could convince Mr. Swaby to allow the court to do that.
yo puedo convencer al señor Swaby que permita que el juez haga eso.
Understood.
So I
Entendido.
must deny your request for a transfer right now.
Así es que debo de negar su solicitud para una transferencia en este momento.
Anything else, Mr. Yoder?
Señor Yoder, ¿alguna otra cosa?
Your Honor, I'm looking for a further proceedings date in the near future. What would be the next available Wednesday we could
Hi, Albus.
potentially submit a plea to the court?
Su señoría, estoy buscando una fecha de procedimientos adicionales aquí próximamente en el futuro, así es que ¿cuál sería el próximo miércoles que esté disponible para el juez, donde posiblemente podamos someter un convenio declaratorio ante el juez?
September 24 or October 1?
24 de septiembre o 1 de octubre.
September 24, please.
24 de septiembre, por favor.
Anything else, Mr. Yoder?
Señor Yoder, ¿alguna otra cosa?
No, thank you.
No, gracias.
Mr. Swaby, anything else?
Señor Sueve, ¿alguna otra cosa?
Yay,
No.
Terry. Thank you. That's
Cause
awesome.
coming off for
11
initial
months.
hearing.
Causa bien ante el juez para una audiencia inicial.
Defendant appears in person from the Elkhart County Correctional Facility.
El acusado comparece en persona desde la cárcel del condado de Elkhart
And by his attorney, Mike Yoder,
y por su abogado Mike Yoder.
both by WebEx.
Los dos de ellos por WebEx.
Shut
State
up,
of Indiana
JK. I
appears
mean,
by Deputy
yay,
Prosecutor Attorney Robert
JK,
Swayze.
thank you.
El estado de Indiana comparece
Thank
por el
you,
fiscal
JK.
adjunto Robert Swayze.
Certified interpreter Adrian Aguilar appears and translates the proceedings for the benefit of the defendant and the court.
Intérprete certificado Adrián Aguilar comparece
Like a
a
prison
través de Webex y
sentence.
traduce los procedimientos para el
No
beneficio
good
del
time.
acusado y del juez.
Mr. Aguilar appears via WebEx.
El señor Aguilar comparece a través de Webex.
Court conducts initial hearing.
El juez realiza una audiencia inicial.
Terry, thank
Court
you.
enters preliminary
Thank
plea
you.
of not guilty for the defendant.
El juez ingresa una declaración preliminar de no culpable para el acusado.
Pretrial conference scheduled for October 1, 2025 at 8:30 a.m.
Una conferencia previa al juicio está programada para el día 1 de octubre de 2025 a las 8:30 de la mañana.
Ominous date scheduled for October 29, 2025.
El 29 de octubre de 2025 se está programando o estableciendo la fecha general.
Trial status conference scheduled for November 12, 2025 at 8:30 o'clock a.m.
El día 12 de noviembre de 2025 a las 8:30 se está estableciendo la conferencia de estatus la conferencia de estatus de juicio.
Jury trial scheduled for December 8, 2025 at 8:30 o'clock a.m.
Juicio ante un jurado está siendo programado para el día 8 de diciembre de 2025 a las 8:30 de la mañana.
Defendant acknowledges jury trial setting on the record.
El acusado reconoce el establecimiento de juicio ante un jurado para el acta.
Court schedules further proceeding date for September 24, 2025 at 8:30 o'clock a.m.
El juez está programando una audiencia de procedimientos adicionales para el día 24 de septiembre de 2025 a las 8:30 de la mañana.
It is so ordered.
Es ordenado.
Mr. Yoder, I did
Señor
not
Yoder.
give you September 8 as a further, excuse me, start again.
Señor Yoder, no le di a
Yoder.
usted el día 8 de septiembre, perdón, comenzar una vez más.
Mr. Yoder,
Señor Yoder,
I did not give you September 10 as a further proceedings date.
no le di a usted la fecha del día 10 de septiembre como una fecha de procedimientos adicionales,
Because we are scheduled to start a jury trial September 8.
porque nosotros estamos programados para comenzar un juicio ante un jurado el día 8 de septiembre.
If that jury trial goes out,
Si ese juicio ante un jurado es desocupado,
and we will likely know that
Shut up, Judge. Thank you so much. I appreciate it, Eileen. Thank you so much.
tomorrow,
y probablemente nosotros vamos a saber eso el día de mañana.
and you can get your documents ready,
Y usted puede alistar sus documentos.
Do you really want bailed out, though? I mean, think about it. Just think about it for a second. So, if this was Georgia, those prisons are awful, awful, awful. But Indiana, or oh no, you're in Georgia. Yeah, I'll bail you out. I'll bail you out the second I know you're in there. Yep.
if you notify me, I will put you in for further proceedings on September 10.
Y si usted me notifica, yo lo pondré a usted para procedimientos adicionales el día 10 de septiembre.
Hi, Smith. Hello.
It's just that nobody has advised me that that case is going to plead.
Es que nadie me ha informado a mí que ese caso se va a resolver a través de una declaración de culpabilidad.
Thank you, Mr. Yoder. Thank you, Mr. Villas de Jesus. You're all done.
Gracias, señor Yoder. Gracias, señor Veloz de Jesús. Han terminado.
If you don't get
Thank-
indicted and they try to make you sit there, I will break open the prison and get you out.
Your Honor.
Mr. Yoder, you didn't have anybody else, did you?
I do not. Thank you.
Anybody in the gallery
Thank you.
need Mr. Aguilar to translate for him? I see
No,
no
Alun-
hand.
no, Judge. No. We're gonna move to El Paso, Colorado now. We're gonna switch gears. We've done enough of Cristofino. This is a new judge for me too, so I didn't see this docket. So I don't know how good or bad it's gonna be.
All right, I do find that Mr.
No,
Miller,
I did not give you permission to get started, woman. You need to chill your roll. All right, hold on. it's just the wrong size. That's good enough, right? Yeah. Here we go.
Years before the court in custody. We have two cases for you today. There is probable cause in both of them. 25M 5532, the charge is third-degree assault, a Class 1 misdemeanor. And then in 20M 3945, the charges are third-degree assault, Class 1 misdemeanor, and harassment, a Class 3 misdemeanor. Sir, do you understand the possible penalties for those charges?
Yeah.
All right. I do find these to be acts of domestic violence. Do we have Terry Rodriguez on the line? Does the district attorney's office have any information from the victim?
No, Your Honor, we did attempt to contact her before today's court date, but did not hear back.
All right. Mr. Miller, the protection order for these cases will state that you are to have no contact of any kind with Terry Rodriguez. You are ordered to vacate the home that she lives in. You are ordered not to share the same residence with her. I do find it appropriate to order for the safety of the victim that you not possess or consume any alcohol or controlled substances. Sir, are you acknowledging the terms and conditions of the protection orders?
Yes, ma'am.
All right. Do you need to keep the peace order to get property out of a shared residence?
Yes, I would.
I will authorize on one occasion. Excuse me?
Clothing and some other items, like my wallet.
I will authorize on one occasion you may go back to the shared residence, but only when you have arranged for law enforcement to be there with you. The purpose is to retrieve a few basic items of your personal property. Other than that, you are not to be at that residence and you are not to have any contact with Ms. Rodriguez. I will make a finding of force in both of these cases. Does the defense wish to argue regarding bond?
Yes, Judge. I'm asking the court to follow the recommendation in the pretrial services packet for a supervised PR bond. I would note that Mr. Miller has been a resident of Colorado Springs for many, many years. He does have a daughter who is local. I didn't see any criminal convictions for Mr. Miller since a 2012 DUI, so hasn't accrued any criminal convictions in many years. I would also note, Judge, he is appearing before the court requiring the use of a walker. He is in his 60s, I believe, and obviously has some physical health issues that he is dealing with. So based on all of that, Judge, I am asking the court to follow the pretrial services recommendation for a supervised PR bond.
What is the district attorney's office position, please?
Yeah, people are asking for a $3,000 cash surety of property bond in each case. We do have concerns about the victim's safety, given allegations in both cases, allegations of physical violence against her. While I agree with defense counsel that I didn't see any recent convictions for Mr. Miller, he does have quite a few prior arrests for domestic violence against the same listed victim dating all the way back from 2008. Looks like the vast majority of those cases would get set for trial immediately. The victim would be unavailable for trial, and then the cases would be dismissed. And so while I acknowledge there aren't any prior recent convictions, I do have concerns about this pattern that I'm seeing of domestic violence. And so based on our concerns for victims' safety, we do think the $3,000 cash surety property bond in each case is appropriate. Thank you.
Thank you. Mr. Miller, the court has considered your individual circumstances. I've considered your other criminal cases, the statements of your attorney, and the position of the district attorney. I do have concerns for the safety of the victim. In these cases, both of these cases do involve acts of physical violence against Ms. Rodriguez. I also did see a number of dismissed cases involving Ms. Rodriguez. Certainly none of those were convictions, but it is a concern. The court is going to set a $3,000 cash surety property bond in each case. It will be a condition of your bond, sir, that you not possess or consume any alcohol or controlled substances, and that you submit to random sobriety monitoring upon your release from custody. Your next court date is September 8th at 8:30 in Division H here in the El Paso County Courthouse. Thank you, sir.
Thank you.
All right, can you hear me at the Teller County Jail?
I've been,
Yes.
we're supposed to be doing El Paso, Judge. Just El Paso. You don't need to do Teller County Jail. Teller County needs to get their own judge.
What is your name, sir?
Brian Gordon.
Sir, you are appearing in video advisement court this afternoon for Teller County case number 25T1019. Did you watch the video there at the Teller County Jail?
Yes, Your Honor.
Do you have any questions about your rights?
No.
All right, I do find that Mr. Gordon appears before the court from the Teller County Jail. 25T1019 charges you with no insurance, a class 1 traffic misdemeanor, careless driving, a class 2 traffic misdemeanor, hit and run, a class 2 traffic misdemeanor, fictitious plates, a class 2 traffic misdemeanor, driving under the influence, that's an unclassified misdemeanor, and let's see, driving with a revoked license, which I think is a Class A traffic infraction. Sir, do you understand the possible penalties for those charges?
I do.
Okay. Your bond is set at $1,000, cash, surety, or property. Does the defense wish to argue regarding bond today?
Yes, thank you. What I was able to see is that Mr. Gordon is already represented by my office, indicating that he qualifies for the public defender's office out of custody. I noted that he has that one case that is currently pending. And I did not see, other than that pending case, a long or lengthy, significant prior criminal history. It looks like he has been making his court dates. I didn't see any significant failure to appear history. I would be asking for supervised personal recognizance bond. If the court felt it was appropriate, I would ask for monitored sobriety or any other conditions that the court thought were appropriate to impose for this kind of case.
What is the DA's position, please?
The people have asked that bond remains set as is. We do have concerns about the defendant's ability and willingness to abide by court orders. He is facing a charge of driving under the influence in 25T1011 out of Teller County. He was already granted a personal recognizance bond in that case of $1,000 and posted that in June of 2025, but then is alleged to have picked up this second DUI only a few months later. And so based on our concerns about his continued drinking, his continued driving, as well as his disregard for court orders, we do think bond is appropriately set as is. Thank you.
Thank you. Mr. Gordon, the court has considered your individual circumstances. I have considered your other criminal case, the statements of your attorney, and the position of the district attorney. I do have concerns for the safety of the community, given the allegations here. I'm also concerned because 25T1011 is another DUI case that you are on a personal recognizance bond for already. You have been on that status since June 7th of 2025. I also noted that in that case, you missed 3 of your UAs in July. And so I certainly don't find that putting you on another personal recognizance bond with substance abuse monitoring would do any good. Bond will remain at $1,000, cash, surety, or property.
Nice.
Will be a condition of your bond that you not drive unless you have a valid driver's license. You are ordered not to possess or consume any alcohol or controlled substances. You will submit to random sobriety monitoring upon your release from custody. Your next court date is September 22nd at 9 o'clock in Division T. That's in the Teller County Courthouse in Cripple Creek. Thank you, sir. You're all set. All right, jumping back to CJC, do we have Mariana Aguilar? Hi, what's your name?
Mariana Aguilar.
I just figured it out, guys. That's why. This is El Paso, but they're doing other counties because this is absolutely a Saturday. Or it could have been the holiday that just Labor Day. That's why it's not just El Paso. I thought we were just going to do El Paso today, but we're not.
Did you watch the video today?
Yes.
Do you have any questions about your rights?
No.
I do find that the defendant appears before the court in custody. There is probable cause in case number 25M5526. The charge is second-degree criminal tampering. It is a Class 2 misdemeanor. Do you understand the possible penalties for that charge?
Yes.
Okay, I do find this to be an act of domestic violence. Do we have Edgar Negrit
What did she
Flores
tamper
on the line?
to be domestic violence? What did she tamper?
Does the district attorney's
Brakes?
office have any information from the victim?
Did she tamper with his brakes? You should not do that. I know.
Yes, Your Honor, our office spoke with the victim earlier today. The victim is requesting a PR bond and would like to see the defendant get out of jail, but is asking that the mandatory protection order remain fully in place. Thank you.
All right, thank you. Ms. Aguilar, the court will set the terms of the mandatory protection order at this time. You are ordered to have no contact of any kind with Edgar Negret Flores. You are ordered to vacate the home that he lives in. You are ordered not to share the same residence with him. Do you need to keep the peace order to get property out of the shared residence?
Yes, please. I need my vehicle.
All right. I will authorize on one occasion, you may go back to that residence, but only when you have arranged for law enforcement to be there with you. The purpose is to retrieve a few basic items of your personal property. Other than that, you cannot be at the residence and you cannot have any contact with the victim.
I have one question. Where I stay at, where I can stay at with my family, they live in the same neighborhood. Would that be a problem?
Well, the way that would work is that if you see the victim anywhere, you have to turn and go the other way. You certainly cannot be in the same residence with him, but it's your responsibility to make sure you avoid contact with him. That's not his responsibility, okay?
Kelly,
And the keep the peace is needed for,
if you have to stand up or stretch in any way, don't do it. Don't worry about it. But just, if you could type something into Twitch, I have a thing I want to look at. Just a thing. It doesn't mean anything. So if you, pirating. Why, Sherry? You're a big part of the stream. So I don't get YouTube judges on here very often. Sometimes I do. But most of the time, like, these judges are exclusive to this channel because they are not on YouTube. Most of the other court channels only do YouTube judges. And they all do the same judges. They watch the same dockets. And it's hard. It's easy for them because YouTube judges are all recorded. And they can go back at their leisure and record a clip and get it again if it's wrong. But the dockets that I get are all live, and they're not on YouTube, and I have to find them. And there's no rewinding. So that's why if you look, the first time I saw Judge Fleischer, he wasn't on screen at all. It was just, the camera was in Ramona's room, and I think pointed out towards the defendants that were coming up. But you didn't see Judge Fleischer at all the first time I got him. And, I just happened upon that docket that was live at that time and pressed record. And just then later that day, I went and I looked through all my recordings because, you got to get it. You have to get it while it's live. You can't rewind it. You can't go back later. You can't do any of that. So I got him when he was, I watched him later, and he wasn't on screen at all, and I released it that night on YouTube. over the moon with this judge. So I released it on YouTube, and I'm like, guys, sneak preview of this judge. This judge is great. And we didn't even see him. We didn't even see his face. We just heard him, and it was awesome. And then the next day, when I got to show his full docket, the camera was finally on him. Oh my gosh. And then, you know, it's just funny because, you know, visually watching him is just impressive. He is just impressive. But we fell in love with Judge Fleischer before we ever seen Judge Fleischer. We instantly fell in love with him just because the way he handled court, just because of his words, just the way he spoke to the defendants. Instead of just, you know, their number, like, this judge isn't talking to her. She's just not. She's not talking to her. She's giving her information, and that's it. Judge Fleischer speaks to each one of them, and it's not always great because they can incriminate themselves. Though he tries not to let them incriminate themselves. But yeah, it was a good night. That was such a good night when that first video went out of Judge Fleischer. That was so good. I miss Judge Fleischer, really, really, really. I think it's been long enough. But in my humble opinion, he needs to start streaming now for his upcoming election. I just think it would be helpful for him. But no, Kelly, I want to see something in Twitch. So you specifically, if you could say anything in Twitch, that would be awesome. You don't have to. If you have to stand up, look, standing up sucks. If you have to stand up, don't worry about it. I'll do it next time. It's not a big deal.
For the address on Accolade Circle, correct?
Yes.
Okay. All right. Let's see. I will not make a finding of force in this case. The court is inclined to release the defendant on a supervised PR bond. Is there any objection from the DA?
No objection, Your Honor.
Any objection from the defense?
No, thank you.
All right. Ma'am, I will authorize your release on a $2,000 supervised personal recognizance bond. You don't have to pay any money in order to be released from jail. When you are released, I want you to contact the El Paso County Pretrial Services Office and follow their instructions. They will assist you with court date reminders. Your next court date is September 8th at 8:30 in Division H. That's here in the El Paso County Courthouse. Thank you.
Thank you.
Andrew Bicknell.
Look at you sneaking in a chair without me even knowing. Thank you, Josh. Thank you for the 100 bits.
Hi, what's your name?
Andrew Bicknell.
I missed it, and I would not have seen it if I wouldn't have been checking out Kelly's information. So, no, Kelly, you did exactly what I needed you to do. You can get off Twitch if it's giving you ads. Screw the ads. But thank you, Josh.
Did you watch the video today?
I did, ma'am.
Do you have any questions about your rights?
No, ma'am.
I do find that the defendant appears before the court in custody. There is probable cause in case number 25M5535. The charges are first-degree criminal trespass, a Class 1 misdemeanor, and obstructing government operations, a Class 2 misdemeanor. Do you understand the possible penalties for those charges?
I do.
I also see a parole hold for you, sir. Your bond in this case is set at $800.
Thank you,
Is
Kelly.
the defense
Thank you.
reserving bond argument for the next court date?
Yes, we would like to put the people on notice that we'll address bond at the next court date. Thank you.
All right, thank you. So sir, for now, your bond will stay at $800, cash, surety, or property, and that next court date is September 9th at 8:30 in Division H. Thank you.
Thank you.
Michael Coggins. Hi, what's your name?
Yes, thank you. Thank
Michael
you.
Coggins.
Did you watch the video today?
Yes.
Do you have any questions about your rights?
No.
I do find that Mr. Coggins appears before the court in custody. There is probable cause in 25M5527. The charge is violation of a protection order. It's a class 1 misdemeanor. Do you understand the possible penalties for that charge?
Yes.
I do find this.
Thank you so much. Thank you. And it was absolutely my pleasure. I love him. I do love him. But look, this is a new judge that you're watching right now. No, he is not Judge Fleischer, but it's a new judge, and every day I'm trying to bring new judges so we can find more that will, mean something in our lives, just like he did. Not like he did. He's one of a kind, but maybe close.
To be an act of domestic violence. Do we have Ramona Hernandez Coggins on the line?
Ramona.
Yes, ma'am.
Thank you for being here. I will be making decisions today about bond and about the mandatory protection order. You are welcome to address the court, but you're not required to do so. What, if anything, would you like me to know?
This time around, Mikkel and I were trying to work through everything, and I wanted to see if maybe we could modify the protection order, but he can come around, but he can't harass or yell or belittle, that kind of thing. I think Kel's biggest problem is that he needs to address some of his mental issues and his anger issues. He's doing really well. He's actually going to school. He's working. He's got almost a 4.0 GPA right now. He really is trying, but I think that addressing his mental issues probably needs to be his top priority. I do not feel he did not threaten me. He didn't physically do anything to me. He was just being aggressive. And that was the first time that he's been that way since he was released from jail this past time. And I just think that he's under a lot of pressure right now, and that if he went to counseling, that would really help him a lot.
All right, thank you. Sir, I will set the terms of the mandatory protection order at this time. For now, I am ordering that you have no contact of any kind with Ramona Hernandez Coggins. I'm ordering that you vacate the home that she lives in. I'm ordering that you not share the same residence with her. For the safety of the victim, I do find it appropriate to order that you not possess or consume any alcohol or controlled substances. Sir, are you acknowledging the terms and conditions of the protection order?
Yes.
I will note that the specific terms of the protection order can be addressed again and potentially modified at the.
I have to point something out. I have to, even though I just typed it, I'm going to say it. I want to okay, if you look in the Twitch window on your screen, Josh is in bright red. Josh is wearing bright red today. And we all know what that means because we just looked it up online. Josh is a violent criminal and Josh is a worker. So there we go. We got a violent worker right here sitting beside us. And he's from Utah, so I don't know what that means, but it means something.
The next court date, I have made the conditions in this protection order consistent with the ones in 23 CR 2312. Sir, do you need to keep the peace order to get property out of a shared residence?
Yes.
I will authorize on one occasion you may go back to that residence, but only when you have arranged for law enforcement to be there with you. The purpose is to retrieve a few basic items of your personal property. I will not make a finding of force in this case. Does the defense wish to argue regarding bond?
Yes, thank you. So I would just echo some of what the named victim just said. He has ties to the community here. He's in school. He's working on maintaining his grade point average. This was based on what I could see in the probable cause affidavit, just a verbal argument, nothing physical, nothing like that. Per the victim's own request, she wants him back in the community so that he can continue to work on some of the issues that he's facing. I did note that he had been previously represented by the Public Defender's Office, which indicates to me that he would qualify for representation and cannot afford a very high cash surety or property bond. I noted that they share children, and so to the extent that he is able to be back in the community with his family, I think my clients are always best served that way. I noted a failure to appear in 2023, but nothing in the last couple of years since then. And so we would be asking for a supervised personal recognizance bond with any additional conditions that the court thought were appropriate.
Thank you. What is the district attorney's position, please?
Your Honor, the people are asking for an elevated cash surety or property bond in this case. I do have concerns about the defendant's ability and willingness to abide by court orders, given that he is already on supervised probation and 3 other cases, all domestic violence based, all against the same listed victim. And he was recently revoked and regranted in 23 CR 2312 only a few months ago on June 30th of 2025. So people do have concerns about the defendant's continued behavior around the victim, as well as his admission to law enforcement that he was consuming alcohol, which would be in direct violation of his probation conditions. So based on that, we are requesting an elevated cash surety or property bond.
Hi, Walter.
Thank you. Mr. Coggins, the court has considered your individual circumstances. I have considered your other criminal cases, the statements of your attorney, and the position of the district attorney. This in and of itself is not a violent offense. However, I do have concerns for the safety of the victim, given the alleged violation of the protection order, specifically that you were residing with her in violation of that order, as well as consuming alcohol. The court also has concerns given the convictions in 23 CR 2312, 24 CR 5094, and 23 CR 4912, all of which are domestic violence cases involving Ms. Hernandez Coggins. I am going to set bond at $4,000 cash, surety, or property. I do not find that a personal recognizance bond is appropriate. Sir, your next court date will be September 12th at 8:30 in Division D. That's here in the El Paso County Courthouse. And Ms. Hernandez Coggins, you are welcome to attend that court date, but you are not required to be there. Oh, yes, and as a condition of your bond, it'll be ordered that you not possess or consume any alcohol or controlled substances, that you submit to random sobriety monitoring upon your release from custody, and that you contact your probation officer within 24 hours of your release. Thank you, sir. Jesse Goodman.
Not Goodman. Are you sure?
Hi, what's your name?
Jesse Goodman.
Did you watch the video today?
Yes, ma'am.
Do you have any questions about your rights? Okay. I do find that Mr. Goodman appears before the court in custody. We have 2 cases for you today. The first one is 25M5632. The charges there are unlawful possession of a controlled substance, a class 1 drug misdemeanor, actually 2 counts of that same thing. And then your other case is 25M5528. There is probable cause in that matter for harassment, a class 1 misdemeanor. Do you understand the possible penalties for those charges?
Yes, ma'am.
Hi,
You are on a
Jenny.
summons for the misdemeanor drug case. And then for the other case, 25M5528, I do find that to be an act of domestic violence. Do we have Dusty Cowan on the line? Does the district attorney's office have any information from the victim?
No, Your Honor, we did reach out before today's court date, but did not hear back.
All right, Mr. Goodman, the terms of the protection order for that case will state that you were to have no contact of any kind with Dusty Cowan, C-O-W-A-N. You are ordered to vacate the residence that she lives in. You are ordered not to share the same residence with her. Are you acknowledging the terms and conditions of the protection order?
Yes, ma'am.
I will make a finding of force. That means that within 24 hours of your release from custody, you are required to relinquish all firearms within your possession or control, and you must complete a firearms affidavit. Does the defense wish to argue regarding bond?
Yes, thank you. If the court is not inclined to grant a personal recognizance bond, we would ask for a nominal bond in the case that he is on the summons for right now, which I have is the 25M5632 case. But we would be asking the court to consider granting a PR bond in the other case where bond is set. I noted that he had been represented by the public defender in the past, which indicates to me that he cannot afford a very elevated cash surety or property bond. I did note that there was at least one failure to appear from last year, but I did not see multiple failures to appear from the last year or anything like that. So he is capable of coming to court and maintaining contact with his attorney. And so we would ask for a personal recognizance bond, perhaps an elevated supervised personal recognizance bond if the court thought that was appropriate.
Thank you. What is the district attorney's position, please?
Yeah, the people are asking for an elevated cash surety property bond. We would note the defendant is already on supervised probation in 24M747 for prohibited use of a firearms charge. I also noted numerous prior DV convictions with a different listed victim, but looks like he has been previously convicted of violation of protection order, harassment, strike, shove, kick, as well as a felony assault. Again, all against different victims, but over the last 5 years or so, based on his criminal history, the allegations in this case, and the fact that he's already on supervised probation when he's alleged to have picked up this new offense, I do think an elevated cash surety property bond is appropriate. Thank you.
Thank you. Mr. Goodman, the court has considered your individual circumstances. I have considered your other criminal cases, the statements of your attorney, and the position of the district attorney. I do have concerns for the safety of the victim, given the allegations in the probable cause affidavit does include allegations of physical violence. I also have concerns based on your conviction in 21 CR 4483. Looks to me like you are currently on supervised probation for domestic violence strangulation involving a different victim. I also see the conviction involving a firearm and the deferred sentence involving controlled substances. I am not going to grant a personal recognizance bond. The court will set bond in that case at $4,000 cash, surety, or property. And then in 25M5632, at your counsel's request, I will revoke the summons and impose a $10 bond. See, your next court date for both of these cases is September 5th at 8:30, and that's in Division J here in the El Paso County Courthouse. Thank you.
Yay, Zach. Thank you. Thank you, Zach.
What's your last name?
All right, let's call Robert Connor, and I don't know how to say the last name, Tocarciuc.
Hello, Your Honor.
And can you tell me your last name, please?
Yes, ma'am. It's Tokarsu.
Tokarsu, thank you. All right, sir, did you watch the video?
Yes, ma'am.
Do you have any questions about your constitutional rights?
No, ma'am.
I think
I do find that
we don't really get a lot of east winds. We get, from Canada. We get hit with winds from Canada. That's why where we sit, we get a lot of snow, because it swoops down and then right back up again on the other side of New York.
the defendant appears before the court in custody. Your case number is 25 CR 3878. There is probable cause for motor vehicle theft, a class 4 felony, and altered or removed identification number, a class 5 felony. Do you understand the possible penalties for those charges?
Yes, ma'am.
All right, your bond is currently set at $3,000 cash, surety, or property. Does the defense wish to argue regarding bond today?
Yes, Judge, we're asking the court to consider a supervised PR bond or a lower cash or surety bond. I would note that Mr. Tokarsu is a high school graduate. He is self-employed, so he does have employment. I believe he does have a cell phone, and he has family local. His father is here. He has a fiance here as well.
And my daughter's due any day. My daughter's due any day.
I wasn't privy to that information. Apparently his fiance is pregnant as well, and their daughter is due soon. So based on that, Judge, I'm asking you to consider a reduction in bond.
Thank you. What is the district attorney's position, please?
The people that asked the bond remains set as is. I would note that the defendant is currently on, we've supervised probation out of 24 CR 3664. I believe that case is pending revocation. He is scheduled to return to court in about a week or so. But I'm showing that he is on a no bond hold in that case, at least according to my notes. In data access. At any rate, given the fact that the defendant was on supervised probation when he is alleged to pick up this new offense, we do believe bond is appropriately set as is. Thank you.
All right, I was a little confused about that bond situation in 24 CR 3664 as well. In any case, sir, the court has considered your individual circumstances. I have considered your other criminal cases, the statements of your attorney, and the position of the district attorney. I do see that you are on probation for a class 4 drug felony in 24 CR 36.
We get a foot at least once a year. At least once a year we get 12 inches. And then a couple times a year we get like 7 or 8 inches. We get a lot of snow.
6-4 out of Division 21. I also see that you have a pending Class 1 drug misdemeanor out of Division C. I also see at least 2 prior convictions for motor vehicle theft. I'm referring to 17 CR 4301 and 18 CR 4795. You served DOC time on both of those. Here we have another allegation of a motor vehicle theft, as well as you being incapacitated by your involvement with drugs or alcohol or both. The court is not going to reduce your bond. Your bond will remain at $3,000 cash, surety, or property. It will be a condition of your bond that you not possess or consume any alcohol or controlled substances, and that you submit to random sobriety monitoring upon your release from custody. I'll also order that you contact your probation officer within 24 hours of your release. Your next court date is September 11th at 3:45 in Division DST. Thank you.
Your Honor, do I have a no bond hold in the other case?
I really can't tell. I'll look again.
Because my fiance posted my bail.
Hold on.
Sorry.
That's okay. All right, so it looks like my guess is no, but you can't hold me to that because it's not my case, right? The reason I say that is that the most recent complaint and report from probation was filed on August 6th of 2025. There is no warrant associated with that complaint and report. I also see that you appeared in court after that document was filed. You appeared in court on August 12th.
Judge, if
and
I may,
the rep-
I'm looking at the jail website and there's only this bond on the
Yes,
jail website.
Yes, I am aware of that. Thank you. And it looks like Judge McHenry did reference a summons being in place for that 3664 case in the minute order on August 12th. So my guess is that you're on a summons for that case and not being held. But the jail, folks at the jail, I think they typically will run your name again to make sure you're clear for all warrants before they release you. And that would be the best way to verify that. Okay?
Thank you.
All right. You're all set. Okay.
All right, guys. We did it. We made it to the end. I'm going to start up OJ. This is not a keeper, Judge. Unfortunately. It's all right. We'll try again. We'll keep trying. Keep finding new judges. Thank you so much for coming out today, guys. I really appreciate it. I really do. And I shall see you all again really soon. Thanks, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf. Join in the laughter. Come and see for yourself.